an interesting way it's being dealt with.
This offense, if you were to plead guilty or be found guilty, is death or imprisonment for life. Do you understand?
Yes.
It's my belief that the inclusion of the police internship through Pullman PD was the police's attempt to prejudice Kohberger and make him look like a cop or a cop wannabe to the public, to make him kind of look creepier. But damn, we should have known he got the job. I was totally not expecting to find it. Check it out. In these stickers used to redact Kohberger's email address, it states employees info. It actually states that twice, and obviously from the email, and it reads, quote, Chief Jenkins, it was a great pleasure to meet with you today and share my thoughts and excitement regarding the research assistantship for public safety. I look forward to hearing from you. Best regards, Bryan. End quote. Gary Jenkins writes back, quote, Bryan, great to meet you and talk with you as well. Gary, end quote. Sounds like a guy who landed the job to me. Sit on this. Technically, the report should have read, Pullman Police Department intern Bryan Kohberger arrested for Idaho student murders. That narrative would have fit a lot more, I think, and even the pro-Bryan's innocence side, because a lot of us have been saying it was either the cops or had something to do with the cops. Not to be construed with having something to do with Kohberger necessarily, because obviously the police knew that apparently the victims were in a position to be murdered by their own kind, and it's notable that whenever they go to pin this on someone, they pin it on someone who was allegedly pro-blue. And hello, I don't think that Bryan's exactly the loser drug addict that people are trying to make him out to be. And the dude has a master's degree and was continuing did I say continuing? He was continuing his education, doctoral education, okay? Why the hell would he do that if he had some kind of felonies that he's working off or some kind of charges that the feds are hanging over his head? I highly doubt that he was working for them other than as some sort of operative, agent, farmer, provocateur, infiltrator, mole, however you want to phrase it. As has been noted, this often happens in public corruption cases. It's notable that the entire east side of Pennsylvania, shortly before Bryan Kohberger moves out to Washington, was having yet another round with its public corruption probes and indictments. Almost every single city he's ever lived in has been a subject to this type of investigation, including back in 2009. Police began the FBI probe against the governor and the governor's right-hand man, as journalists called him Capitol Hill insider John Estee. John Estee is now officially a criminal, pleads guilty to scamming the FBI. That's right, this guy gets with the FBI and they're like, you know what? If you don't want to go down with him, then this is what you're going to do. You're going to take him this bribe. You're going to split it 5 ways, and we're going to prove that these guys are taking bribes and promoting kickbacks in a play or pay scheme. Estee goes, okay, leaves, pockets half the money, and only bribes the officials with the other half. That's right. Now, it was noted that Estee later wears a wire for up to 3 years for the FBI during this probe, and the arrests are still being played out over the news and through press releases into 2021. This would include the Allentown mayor, kickbacks, and public corruption in the Pennsylvania school district that Bryan Kohberger was actually working for as a security guard. Antioch gets busted, somehow intertangled with the Pittsburgh task force and police, who were also indicted for public corruption for their racist antics, attacking the public and innocent, many times completely innocent individuals with a police dog that had to be retired because they had utilized it to attack so many innocent individuals, and mostly individuals who were of color. Now, it's also, of course, notable that Estee, however the hell you say his name, could possibly be related to the Estee from the 1122 King deed. Dan Estee, who notably, according to the web, is from Maine, which is not terribly far and is pretty much in the same side of the country as Pennsylvania, so not very far away. They share a last name. Do they share a relation? Because this is an interesting connection indeed. FBI probe informant Estee. Remember when I conjectured if the house had actually been a part of asset seizures amongst criminals who were busted in some other investigation? One truly does wonder about that, because papers and agents of the 1122 LLC began to get switched around in exactly the year 2009, and this continues on and throughout until 2018. Notably, Hill and Perky and Estee have shifted the 1122 King resident, an asset that they manage, back and forth between one another as quitclaim deeds, which means they're essentially not paying any money for it and they're just transferring the names back and forth. So Estee has been the deed holder for the 1122 King residence more than once.
And a role to play in this includes, this is my role as the parent.
He says he's raising money to hire a private detective.
They're trying to erase it. An interesting way it's being dealt with.
But this on the order of interesting, but on 9/8/2023, we see a new wave of warrants. One from Amazon, one from Apple, another from PayPal and Venmo, Spotify, and then YouTube. A warrant for someone's YouTube studio, including all analytics on all of their videos and all information pertaining to their monetization. An apparent monetized YouTube partner has been warranted discoverable in the Idaho 4 murders, and we wonder who it is. Also, that's Spotify. Who the hell's Spotify do they want? That some love to love and others love to hate. Bethany was not only summoned to court to testify, but to bring a document. In fact, there's actually no subpoena that's been unsealed that allows us to see that she was actually ever asked to testify. The only hints that we have she was asked to testify are from her attorney in Nevada and the court records relating to that dispute, which Bethany's attorney brought to the Nevada court asking them to squash a subpoena which had come from the Latah County Court asking her to appear during the preliminary phase of a trial. Now, the attorney at hand notably was not arguing that Bethany would have to come during the trial, but during the pre-trial phase of court. Inevitably, the attorneys come to a deal on this, and the court case is noted as being adjudicated through the Nevada court system. That means that the case was handled and that there was no need for a court order. Basically, the attorneys stipulated. This means that the attorneys were able to come to an agreement that no longer needed the order from the court to squash. But the partially unredacted subpoena request with no one's name on it comes through right after it's noted that the dispute was dropped in Nevada, so we can kind of get the idea that this is obviously about Bethany, and this is a type of subpoena. It's one of two types of subpoenas. There's a type of subpoena which requires a person to testify or bring their testimony, and there's a type of subpoena which requires a person to bring tangible evidence, documents, a phone, a picture. It could be literally anything. But it will be a tangible form of evidence and not just the person's testimony. I think that this is another notable that happens to be a jewel from the court paperwork, which is quite undercovered. Another notable is a stipulated agreement between both attorneys, which agree that none of the Idaho student records, which are not bound by federal laws of non-disclosure, will also be non-disclosed. They won't be disclosed. Okay, so both attorneys agree that all records which would normally be disclosed will not be disclosed pertaining to this case. And also notes that it's entering limiting access for records pertaining to students, faculty, staff, and records from the University of Idaho's Office of Civil Rights Investigation, OCRI, limiting it to direct review by defense counsel and with the provision that any further dissemination or the use of those records is prohibited, absent a specific order or further on the stipulation of the parties. So there they are, taking control of any records which would normally be disclosed. This protective order pertains to the records obtained from the University of Idaho during the course of the investigation of this case. Those records fall into two categories: records pertaining to Madison Mogan, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle. 2, records from the University of Idaho pertaining to other individuals, including students, faculty, and staff, and records from the University of Idaho's Office of Civil Rights Investigation, OCRI. By way of background of records records of the University of Idaho are protected by various federal and state laws, including the Family Educational Rights and Privacy Act for FERPA, as well as various state personal information privacy protections. The state has advised by legal counsel for the University of Idaho that FERPA protections do not survive the death of the subject individual. Consequently, FERPA issues in this case do not apply to the University of Idaho records regarding Madison Mogen, Kaylee Gonzalez, Ethan, and Xana Kernodle. However, other personal privacy protections remain, including protected information as defined by Idaho Criminal Rule. The state will redact the information in accordance with the Idaho Criminal Rule 16D, and the parties will comply with the protections afforded by that said rule. As the University of Idaho records, other than those pertaining to Madison Mogen, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle, the parties stipulate to the entry of a protective order limiting access of those records to direct review by defense counsel, and with the provision that any further dissemination or use of those records would be prohibited absent a specific court order or further stipulation of the parties. The parties recognize that further dissemination or use may require redaction or compliance with FERPA mandates for notice to the subject person prior to their dissemination or use. Respectfully submitted, apparently on the 5th day of June 2023. Another interesting tidbit, the UPS warrant was not just a UPS wanting the girls or Ethan's account. It was actually a request for the video on all Moscow-bound trucks from the Pullman UPS station. What the hell? Yes, all inbound trucks for a very specific date from the beginning of November into 2 days post the murders. Now, let's just say for shits and giggles that corruption could be an underlying factor here. Perhaps the victims had uncovered evidence of police corruption, or they were involved in some sort of investigation that could expose illegal activities within the PD. The PD may have wanted them silenced to prevent their corruption from being exposed. Or the suspect, who later becomes a scapegoat, is an easy target. They frame the quadruple murder on this suspect, and maybe he has some sort of connection to the victims and or that investigation, which was previously mentioned. So they fabricate a story that makes him a believable culprit in the eyes of the public. By focusing on this individual, the PD could divert attention away from themselves and ensure that their own involvement remained hidden. The missing woman report, the calls coming in a college community about noise on Labor Day weekend in one case, in a neighborhood that is basically all college students, who many have responded by asking, who the hell is calling the cops in this place? Important to note that the boys who originally had police at their house, who were, according to the call, the source of the noise complaint. The police go out there, they handle the noise complaint, talk it out with the boys, and then take it upon themselves to warn the King Road residents where the Moscow victims lived, in order to warn them about something that inevitably has not happened. So they did not receive a call about the 1122 King Road residents, yet they go over there. They have a bunch of crazy statements, like noting that they see the JBL speaker, which was actually inside of the back door. The other officer notices that there is no escape or no exit point for the stairs. Oh, there's no stairs for the back deck. Yes, because it's called a balcony, and balconies do not have stairs. But what the hell does he care, and why were they scoping out the place? Now, one really wonders about the police internship allegedly applied for by Kohberger. Now, let's talk about the gag orders. The gag orders and the victims' families. There's always the possibility that instead of being a huge constitutional issue, that what we're seeing here is the victims' families being gagged due to them knowing about undercover investigations and or being involved in their own ways and in their own roles in those undercover investigations. Many times, as people do, we grow up and we do the same things that our parents do often. It's possible that the parents of many of the victims are agents or officials themselves, and this is possibly why they were further gagged along with the attorneys who were actually a party to the case. Obviously, the Gonzalez were worried that this was a reverse patsy, I guess you could say. They were concerned that basically the prosecuting attorney would put someone that was at conflict with representing a defendant so that the defendant could get the case appealed or whatever, have it fall through in some way that doesn't look like it is the prosecution's fault. And, well, oops, we tried. But so I think they were concerned about that kind of thing. And their attorney motions for the court to unseal the hearing or let them know what's going on because it's typically not something that would be sealed to the public, because if you were to seal the hearing about a conflict attorney, then you could only be concerned with the conflicts that the attorneys in that closed hearing know about, and therefore there could be other conflicts that are of concern to the public. So quoting from the motion comes now, or quoting from the order, comes now, the state of Idaho, by and through Latah County prosecuting attorney and the above defendant, the undersigned attorney, and hereby stipulate that the court unsealing the attached redacted copy of the memo summarizing the January 13th, 2023 in-chambers conference, which was filed under seal on January 20th, 2023. The redactions are pursuant to Idaho Court Administrative Rule 32I2D. The following is a summary of the in-chambers Zoom meeting with the Judge Marshall on January 13th, 2023. The following attorneys were present and attending by Zoom: Bill Thompson, prosecutor; Ashley Jennings, senior deputy prosecutor; redacted attorney for redacted; redacted co-counsel attorney for redacted. Damn, some redacted witness has two attorneys. Redacted attorney for redacted; Shannon Gray, attorney for Gonzalez family; and Ann Taylor, public defender for Bryan Kohberger. Judge Marshall and the clerk, Jennifer Oliphant, I don't know if I'm saying that right, anyway, was also present. All right, so this meeting was off the record, and Judge Marshall read the substantive parts of the non-dissemination order that was issued January 3rd, 2023. Judge Marshall reminded the parties that the order mirrors Idaho rules of professional conduct. Judge Marshall directed everyone's attention to the commentary for the rules, specifically subparagraphs 1 and 3. Judge Marshall states that her reading of commentary 3 leads her to believe that the rule applies to all lawyers participating in the Zoom meeting, not only the state and defense, but also attorneys for witnesses. Judge Marshall directed everyone's attention to the commentary for the rule, specifically paragraphs 5 and 7. After the review 3 and 6, Judge Marshall explained that the purpose for the meeting was in response to what she's been seeing and hearing through various media sources. She's tried to ignore most media covering the case since she will be presiding over the preliminary hearing. This case has garnered national and international attention. This is a high-profile case, and she wants to remind all attorneys not to engage in any conduct that would interfere with a fair trial. Because of the nature of the case, this will be a long process. She further advised that it is not responsible for attorneys in this case to disseminate information to the media. She is not ordering clients, i.e. witnesses, not to talk to the media, but she stressed that this case should not be tried in the media but in the court of law. Lawyers involved needed to take their duties in the utmost regard, in direct quotes, when conducting themselves and advising their clients. Judge Marshall stated she wanted to make her expectations clear regarding the lawyers' ethical duties described above. If lawyers fail to adhere to their ethical duties, she will have to fine them in contempt of her order and or report their actions to the Idaho State Bar. She's threatening to have them disbarred here. Important note. He had reached out after the non-dissemination order was issued, asking for clarification, and he didn't receive a response. He asked if the order precludes victims/witnesses from speaking. Judge Marshall reiterated that her order does not preclude witnesses from speaking. Redacted responded that he expects his client, redacted, will be a witness in this case. He also expects that the descendants' families will be witnesses in this case, since it is a potential capital case and they would be called to testify. Now, FYI, testifying is the absolute wrong word for what witnesses are allowed to do in a capital case if they were not testifying for the actual trial, and it's technically a post-conviction, even if that's not what the court calls it, because it's not actually in the categorical post-conviction phase. I hope that makes sense. Okay, so it's basically that phase, but not. It's kind of in a weird gray area, but it's definitely not the same as testifying. You don't get a subpoena. You're not forced to do it. You don't have to do it, and you can actually forego doing it just because you want it to versus testifying in court. Okay, completely different thing that they're trying to convince us that the families fall into right here. It's very strange to see them all like gang up on it. He has handled numerous homicide cases, it says, including capital cases during his career. He assures the court he has advised his client, redacted, to decline all media and will continue to do that. He and his client, okay, there's actually a typo here. It says he and his client and will not comment, but he and his client will not comment as it would be inappropriate to comment. Judge Marshall appreciates Redacted's perspective. Judge Marshall reiterates she is not saying that clients cannot talk to the media, but does question whether it is wise for them to talk to the media, reminds lawyers to have a responsibility to advise their clients, and if any lawyer has questions, then they need to take it up with the Idaho State Bar to seek clarification. Shannon Gray speaks about emailing the state and wanting to contact the court to seek clarification. Mr. Gray stated that he would seek clarity from the Idaho State Bar. Judge Marshall responded that she appreciates Mr. Gray reaching out, but that she has had limited accessibility with a full court calendar. This is why she had scheduled this meeting. Mr. Gray discusses PC affidavit and alleges that information is getting leaked from the prosecutor's office. Judge Marshall reminds the parties about IRPC 3.6 and the lawyer's duties. Lawyers should not be speculating. Judge Marshall says that the public record is what it is in the court's case file, and it is not information reported by the media. Judge Marshall clarifies that attorneys are not prohibited from advising their clients, but they are prohibited from speaking to the media. You can advise your client about what might happen at the status hearing, but you should not be speculating what will happen at the media. So she's actually directly getting on to Shannon Gray about Fox Nation's host, Ashley Banfield, asking him, so you're a prosecuting attorney, Shannon Gray, what do you think? Blah, 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 blah. And so they directly are pissy with him about that. So Shannon Gray speaks about emailing the state and wanting to contact blah, 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 wrong spot. Judge Marshall also reminds attorneys that their statements made must also be true. Who's she getting on to for lying? Mr. Gray takes issue with the interpretation of substantially prejudices, referring to substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. States his client, Gonzalez, have kept this story alive and that their comments have helped the investigation. Judge Marshall explains the necessity of convening an impartial jury in Latah County. The public is obsessed with this case, she says, and comments are harming the ability to impanel a jury. All parties need to allow the judicial process to see this case through. Mr. Gray responds that it is unrealistic to believe that we will find a jury in the U.S. that hasn't heard about this case. Mr. Gray takes issue that he was not given a lot of notice that they would be having this meeting, and he was not given enough time to prepare. Judge Marshall reminds the parties that the Constitution still applies in this case. Lawyers have a duty to uphold the system and allow the system to see the case through. Redacted reminds Mr. Gray that he's creating a record by his media interactions. His statements are being captured by the defense. All of his statements impact the case and advise Mr. Gray to exercise resistance. Mr. Gray takes issue with Redacted's advice. Judge Marshall stops any argument. Damn, Judge Marshall, why you did us like that? Judge Marshall solicits final comments from those in attendance. Prosecutor Thompson states that many of Mr. Gray's accusations are not true. I did not have sexual relations with that woman. Oh, are they not true, Bill Thompson? The state is concerned about the ability to impanel a jury. Dirty dirt. I'm just kidding. Okay, that's not what it says. What it really has said, though, was he is hopeful that all parties will begin to show professional responsibility. Damn, yeah, check yourself or you wreck yourself, Bill Thompson. Looking at himself in the mirror going dirty dirt. Redacted states that she has advised, this is she redacted, redacta Redacta states that she has advised redacted client. She has advised Bethany or Dylan, redacted, not to comment. She takes blank. She takes redacto, the dude redactor, redacted, he who shall not be named. She takes he who shall not be named's position. She takes Voldemort's position. Ann Taylor thanks the court and expresses appreciation. All right, so I have a lot of beef with Ann Taylor and her whole little acting crew over there, but I have a way bigger issue with Bill Thompson and his group of thugs. So you got to take note and kind of laugh that Bryan Kohberger, the one who theoretically should have been more concerned than anyone at the end. Ann Taylor thanks the court and expresses appreciation. No, thank you, Your Honor. I appreciate everyone. Like, what the fuck? Woo! Have I mentioned this fucking case? Because this fucking case. Important to note that here again, we had a case that has Shannon Gray highlighted, historically has been open to the public, that they tried to seal, and that victims' family, Gonzalez's family's attorney, motioned for them to redact what they needed and unseal that shit to the public. Another thing that I've legitimately never ever seen redacted, that I see redacted in this case, is the medical examiner from Spokane, Washington. Where the hell is this examiner, and who are they, and why are they redacted? So why that public official and why that name would be redacted here is kind of conflicting, and this should highlight that could represent a conflict of interest as well. I don't understand that, and I've not seen that before to even speculate much about that for the moment, because I, unlike all of your other favorite YouTubers, just kidding, that was so hatery, just saying, I'm not gonna pretend to know about shit that I don't know. If I don't know something, I'll be like, I don't fucking know, and I have no idea why they would do this, and I've not ever seen that before, so I'm not ready to fully analyze that yet. So another undiscussed form is the Strava warrant. This is for a smartwatch, and it appears to be for one smartwatch. So whose smartwatch was it? Come on, throw them guesses out, because it ain't gonna tell us.